Chapter 3, Legal Issues, Part 4. The first constitutional provision that we'll study as we cover the criminal procedure is the Fourth Amendment. The Fourth Amendment was ratified as part of the Bill of Rights in 1791, and it says, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized." Now, as we'll discuss in the next slide, the Fourth Amendment is generally seen as containing two separate parts. They're related, but they're still treated as separate. The first part is the sentence or the phrase that goes up to the comma after violated. So the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. This is seen as creating a protection against unreasonable searches and seizures. Now we're going to discuss, you're going to hear that word reasonable and unreasonable a lot as we discuss criminal procedure. But this first part of the amendment establishes a basic right, a protection against unreasonable searches and seizures. The second part discusses the process by which the government can obtain a search warrant or an arrest warrant, a seizure warrant. And so it says here that no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So the first part of the amendment establishes a right, protection against unreasonable searches and seizures. The second part establishes the warrant process, how you go about getting a warrant and what's required. The Fourth Amendment was really a response to the colonial practice that the British followed of having writs of assistance. These writs of assistance were provisions within laws that said that the British representatives in the colonies could essentially search a person's house, their business, the person themselves, anytime, anywhere, without any specific reason, solely to enforce particular laws like the tax laws. And so this gave a lot of latitude to the British authorities to basically search at any time, any place. Now these powers weren't given to the authorities in England, but they were given to the authorities in what would eventually become the United States, in the colonies, the American colonies. And so even though the Fourth Amendment may sound like it's some pretty boring language, it actually was one of the major reasons that there is a United States. The subject that it's dealing with, the privacy that a person has in their home, their papers, their effects, their person. And it was one of the reasons that the colonists went to war and declared independence, because they felt that these British writs of assistance denied them the basic rights of English men and women. And so the Fourth Amendment then, after independence was declared and won, and after the United States was established, the Fourth Amendment enshrined those protections for privacy and said, in essence, we know that we're going to protect criminals, we're going to protect some activity that's against the law, but we will sacrifice efficiency for the sake of privacy. We are going to establish a zone of privacy, and government shouldn't intervene unless it has met certain requirements. And we'll discuss what those requirements are as we go along. Now, what is exactly a search? How is it defined? Well, in 1967, Katz versus the United States, the Supreme Court defined what a search was. Now, previously there was an opinion from the 1920s that said there was no search unless law enforcement laid their hands on a person or came inside that person's house or somehow physically breached that person's zone of privacy. But in Katz versus the United States, we had a case where the FBI placed a listening device on the top of a phone booth because they wanted to hear what Katz had to say inside. So they knew under the old law, as long as they didn't go inside that phone booth to listen to him, he was suspected of carrying out gambling operations, so he was a bookie. But the FBI knew as long as they didn't go inside that phone booth and plant a bug on the phone to listen to his conversations, if they only attached a listening device outside the phone booth but they could hear the conversations inside, then under the old law they would be okay, because they hadn't physically breached his zone of privacy. They hadn't physically gone inside the phone booth. And so these were the old-fashioned phone booths where the door would close behind you. Well, the U.S. Supreme Court in Katz versus the United States said, we don't think this is the appropriate standard. We think the protection that's offered under the Fourth Amendment is much broader. It protects people, not places. So even if the police don't physically breach your zone of privacy, if they do it in some other way, then they have conducted a search and they must comply with the Fourth Amendment, which means we'll find out they must have probable cause to have conducted that search. Maybe they need a warrant, maybe they don't, but they at least have to have probable cause in most cases to conduct that search. And we'll define probable cause very soon. So what the U.S. Supreme Court established as the definition of a search, they said a search occurs under the Fourth Amendment if the government breaches a person's reasonable expectation of privacy. So what is a reasonable expectation of privacy? Well, it's really two parts. The first part is the person has to show that they expected their actions, their conversations, whatever, to be private. And then secondly, the courts must determine if that expectation is reasonable. Is it something that society would say, this is reasonable? We are going to allow that expectation of privacy. So, for instance, Katz, when he went inside the phone booth, closed the door behind him, talked in a regular conversational tone of voice, he wasn't shouting, he wasn't, out in the public street screaming out his bookmaking. Instead, he was inside a phone booth, closed the door behind him. Did he show that he expected that his conversation would be private? Yes. Now, was it reasonable for someone on a payphone to expect that their conversations would be private, that government couldn't listen to those conversations unless they showed probable cause? The Supreme Court said, yes, that's reasonable. Most people would agree when you have a phone conversation, the government has no business listening unless it can establish probable cause that there's a crime occurring or has occurred. And so therefore, in Katz, the U.S. Supreme Court said the FBI had breached Katz's reasonable expectation of privacy, therefore a search had occurred, and therefore they had to be in compliance with the Fourth Amendment, which, because they hadn't gotten a search warrant, the Supreme Court established that they weren't in compliance. Therefore, the criminal conversations cannot be used against Katz. So again, the definition of a search is a search occurs when government breaches a person's reasonable expectation of privacy. A seizure occurs when a reasonable person would believe that he or she is not free to leave. So, a seizure, another word for seizure is an arrest, but it doesn't have to be a full-blown arrest. Arrests are a type of seizure. It doesn't have to be that the police put you in handcuffs and say you're under arrest. If the police show through their words or actions that you are not free to leave, you have to remain here, you can't walk away from the police officer, then you have been seized. So if they show in any way that you are not free to leave, you must stop. You must obey the officer at that point. At least obey to the extent of not running away, not leaving the premises, then you have been seized, and once again, the Fourth Amendment applies. If you feel like you're free to leave, if a reasonable person would think they were free to leave, if you're walking down the street, an officer said, hey, wait a minute, and didn't say it in a coercive, forceful way, and you said, I'm busy, I'm going to keep on walking, then that wouldn't be a seizure if a reasonable person would believe they were free to leave. But if you felt that you were not free to leave and a reasonable person also would believe that they weren't free to leave, then that is a seizure and the Fourth Amendment must be complied with. So, under the Fourth Amendment, generally speaking, searches and seizures must be accompanied by a warrant unless an exception applies. Well, we're going to find out in a second that even though the Supreme Court has consistently said we prefer search warrants, in most cases, most searches, most seizures are done without warrants. The exceptions have seemingly taken over the rule. So even though we keep saying when at all possible get a warrant, either an arrest warrant or a search warrant, in most cases that doesn't happen, and there's an exception that allows it to not happen. What are the requirements for a warrant? Well, remember the Fourth Amendment from the last slide? Among those requirements that were found in the amendment, the police must have probable cause. What is probable cause? It's a reasonable belief that a crime has been committed or is being committed. So you don't have to have 100% proof. You don't have to have a belief beyond a reasonable doubt, but it's a reasonable belief that a crime was committed or is being committed. And so the police have to come in with evidence of that. They have to provide evidence under oath. So that's important, because if the police lie in their application for a warrant, they can be brought up on perjury charges. So the police officers have to swear out an affidavit, so they have to have an affidavit of proof, affidavit of probable cause, that lays out what kind of evidence are they relying on to believe that a person has committed a crime or is committing a crime. And then finally, the affidavit has to be specific. It has to be described, and the warrant will describe the persons or places to be searched and the things to be seized. So it has to be relatively specific based on the evidence. Now, you could have a search warrant that allows you to search for all business records, but you're going to have enough probable cause to justify such a wide search. But you don't have to be so specific to say, well, we think that there will be marijuana in this house, and it's going to be in the dresser under the blue socks. You don't have to be that specific. But you can't just say, we're going to search the entire block because there's probably drugs somewhere. No, you wouldn't have probable cause to justify that kind of search, at least most likely. Instead, you have to have probable cause, and the scope of the search will be defined by the evidence that's under probable cause, and will specifically state what's the location of the search, what are you looking for, what are the things to be seized, etc., etc., etc.